call forward the council in 125254 state.
Kurt Kearns on behalf of Devawn Mitchell, your honors. I'd ask for about 5 minutes of rebuttal time.
5 minutes of rebuttal. Brandon.
Well, good morning. If we knew of a citizen that was accused of a crime that went to a trial and was convicted, and we found clear evidence that that citizen did not speak English, all of us would say, well, that's not right. That's not consistent with due process. He should have an interpreter. That's well established. If we had somebody that was accused and went to trial and was convicted, and we had clear evidence that he had a hearing or she had a hearing disability, nobody would have a problem and say, listen, we need to see some kind of evidence that that person had some type of hearing assistance so that that person could be competent, if you will, in the course of that trial. What do we do in a situation where we have clear evidence that we have fluctuating competence, conditions that need to be put in place so that the citizen being tried has conditions that the psychiatrists and the people believe are necessary for he or she to be competent in order to stand trial? We've got an ebbing and flowing history in Kansas with regard to how we deal with mentally ill people. We've not done away with the insanity defense, but we now channel the insanity defense, as our United States Supreme Court puts it. We channel it to the judge. We channel it in making it a sentencing issue. Whereas before, we used to have the ability to say, hey, not guilty by reason of insanity. Look at how the mental health challenges this person has.
What evidence are you relying on that we could look at that shows your client wasn't competent at the time of the trial? I mean, there was concerns and assessment done, and all of the indications are from the evaluations of the professionals was that he was competent at the time of trial.
Justice, I think probably the best way to answer your question is to go right to the evaluation itself, which when you look at the language of it, and if I can just have a second, I'll pull it real quick. What does it say? Well, it says initially in the second paragraph that he lacks the ability to understand the consequences of his own behaviors. It goes on to talk about how he often fails to understand why he would even need to finish the assessment. At the bottom of the first page, it does not seem that Mr. Mitchell understands the consequences of his own behaviors and his own poor choices. It then goes on in the third paragraph on the second page to note that he did not appear to be trying to manipulate the assessment outcome, but he also, in the fifth paragraph of the last page, fails to understand the results of his own poor choices. And then in the concluding paragraph talks about how he does possess the ability to understand legal processes and participate in his own defense if given coaching and support. I imagine each one of us has the ability to understand advanced calculus if given a tutor for a long enough period of time.
But there can be a difference between evaluating competency and evaluating behavioral problems, correct?
There's a definite distinction between those two. Yes, Your Honor.
And the assessment also says that there was a test, the MATCAT-CA, an assessment to determine competency in 3 areas: ability to understand the court process, ability to reason legal strategies, and appreciation of his legal options. In completing this assessment, which was completed, the following results were obtained. In the area of understanding, he scored a 12 out of 16, indicating minimal impairment. In the area of reasoning, he scored a 10 out of 16, indicating mild impairment. In the area of appreciation, he scored a 12 out of 12, indicating no impairment. Assessment outcome was competent. And it also said that the defendant can quickly become uncooperative and combative. At the conclusion, he was coached by us to identify tools he could use to stay calm and cooperative when he returned to his cell. It was presented to Mr. Mitchell that he had a far better chance of reaching his placement goals if he was cooperative with his staff, not screaming or becoming combative. We followed up with staff at the end of the day to see how Mr. Mitchell behaved after that coaching, and he initially tried to walk to the exit door, but was otherwise cooperative. And then at the end, it says, while his behavioral response seems unpredictable and could be highly inappropriate, he does demonstrate the ability to control this. Ultimately, it does appear that Mr. Mitchell is competent to stand trial and or to participate adequately in his sentencing advocacy. So there are parts of the evaluation, including the assessment outcome, that indicate that he was competent in the view of this expert witness, correct?
Yes, with regard to that, and the same evaluator that's making that determination is also in the course of that evaluation discussing all of the coaching and support that they're being provided to get him to that state.
But you have the burden of proof to prove incompetency, correct?
Yes, Your Honor.
And there was no other evidence presented at the competency hearing except this report, correct?
Correct. And with regard to what the judge was aware of, we know that he was committed in 3 separate mental health organizations. There's no dispute about that. We also know he suffered from schizophrenia. There's no dispute about that. There was no dispute that he was, quote, mentally ill. There was no dispute about that either. In fact, what's interesting is that on the second page, the only evidence the court has was also a sentence that said, a comprehensive psychological evaluation could present a much clearer picture of the struggles he has, i.e. KSA 223429. I mean, that's what the judge is actually reading at the time, is the evaluator saying, boy, it'd be nice if we had a comprehensive psychological evaluation that could present a much clearer picture of the struggles. Because gosh, it took us 2 days. It took us 2.5 hours when it normally takes an hour. So the court was in possession of undisputed evidence that we're dealing with a mentally ill individual, an undisputable evidence that we're dealing with somebody who's been committed at least 3 different times, and an undisputable evidence that with the proper coaching and with the proper support, we can get him to the competency level, which he is here now. The question is, was he competent at the time of trial?
In what way do you believe that the district judge who found him competent abused his discretion?
Well, by first off, not reviewing, or at least not understanding the nuance of what the report was saying. And what the report was saying, when you read the whole thing, is we're dealing with a clearly mentally ill person who doesn't understand a whole lot of things. But if we get him right and we coach him right and we support him correctly, we can get him to a state of competency, which he is at the time we wrote this on April 4th of 132, without any examination into, well, what about during the trial when the lawyer brought up the concerns? What about at sentencing after this determination was made? So the abuse of discretion would be the ignoring of the totality of the facts as related in the report.
Criticize the judge for not ensuring that the defendant received coaching and support. But you had the burden of proof. So what did you bring forward any evidence that he was not coached or supported appropriately?
The proof, and I wasn't a trial lawyer, I was just hired for the appeal, but the presentation was, here's the transcript. There isn't any of it. There's no evidence that he was ever coached. There's no evidence that he was supportive. We do have a statement from the trial lawyer indicating that he was acting nutty during the trial, and that's what brought this thing forward and to light. It's also, when the court talked about, his abuse of discretion and things like that, we have a statute that is designed to give judges power in mandatory minimum situations, like we used to when it used to be the insanity defense. We have the statute that says, you know what, if you send this guy off for an evaluation and Larnard says he is an appropriate candidate for treatment and an appropriate candidate when he's on his meds, he actually does pretty well. That's also in the report. But yet the judge was under the understanding he had no power to do anything other than give him the mandatory minimum 557 months. And when in reality, he had every discretionary ability to order an evaluation, to read that evaluation. And that's really what our concern is, Your Honors, is the lack of evaluation. The evaluation might very well come back and say, you know what? He was competent. We've looked into it. There's no problem here.
What's
But
your
we don't
evidence?
know.
What's your evidence that the judge did not understand he had the discretion to ask for an evaluation from Lauren?
Well, because he said so on the record that he had no discretion to sentence him to anything other than the sentence he gave. So if the court is of the understanding, I have no power to do anything other than the 46 years, sorry, but that's what the guidelines call for, then clearly he was not contemplating the full discretion he had in setting him for an individual evaluation pursuant to the statute.
Your client didn't ask for one.
My client did ask that he get evaluated at Larnard. And we have the Crosswinds counseling report stating that we'd get a lot better picture if we had such an evaluation. But as far as anyone saying, I would like an evaluation under, KSA 223429, no one said that.
Going back to the competency issue, isn't this really a sufficiency of the evidence?
If there was any sufficient evidence that any of this was attempted, then yes, but the proof is the lack of evidence in the record completely that anybody sought an evaluation, that anybody got an evaluation, when we have clear evidence in the record, in the report itself, of a very struggling individual who has serious mental health conditions with a history of multiple commitments in mental health facilities, with a conditional report that says he has the ability to be competent if given these things. And so when you have that situation where you're telling a judge, he's got the ability to do this if he does this, with zero evidence that was ever done, we're asking, if not for a reversal, for a remand to actually have that hearing, so that we do know whether any steps were taken to protect that individual. So it's a dual part request for relief.
What's your authority for the claim that the state has an obligation to, or I don't know, the terms that have been thrown out as provide coaching or what have you? Once a determination of competency has been made, as you stated at the beginning, certainly competency can come in and out. But once that determination's been made and supported by substantial competent evidence, isn't it, and then it's not, was it ever raised again and ruled on again?
No, it wasn't raised again. The court essentially set it for sentencing and sentenced the client in accordance.
Well, when did the competency hearing happen?
In April, about a month before the sentencing, after trial, but prior to sentencing. So
that competency determination was made post-trial.
it was made post-trial, and in the motion itself, it pointed out problems during the course of trial that led the lawyer to believe he was not competent. In fact, when you go to the very facts of the case, they're really kind of undisputed. It's all on video, but the first statement out of my client's mouth about this horrible accident is, "Oh, hi, Dr. O, I'm off my meds." And then we have a report months later where people are testifying that when he's on his meds, he gets along pretty well. When he's off his meds, horrible things happen like this. To answer Justice Stiegel's question about what authority we have, well, we have a lot of authority with how I began this argument. We have authority that says sometimes there are conditions that we have to get people to make sure they have a competent representation. We give them a translator. That's to get them competent for
But
trial.
your argument is, as I understand it, that there was no substantial competent evidence to support the district court's ruling that the defendant was competent during trial because
Because
or it wasn't done until after trial and it's irrelevant essentially to what happened before.
well, it is, our position is that the report was brought after trial, but the complaint from the lawyer was brought about during the course of the trial. And there was never any examination into, was he competent during the trial that the lawyer complained of?
Let me clarify here. Initially, pre-trial, there was a motion by defense counsel to determine kind of the notice of intent to determine mental disease or defect. And at the same time, kind of simultaneously, defense counsel had your client seen by some sort of psychologist or psychiatrist that produced a report to defense counsel. And based on that report, I guess, counsel withdrew the motion.
Dr. Jared Steffen, which kind of goes back to when he's on.
So what obligation did the state or the court have at that point to pursue competency when that question was before the court, it was going, and then it was withdrawn?
Well, when we have a later evaluation done at the request of the lawyer that was reviewed by the judge that specifically.
You're talking about the post-trial evaluation.
Right, which basically says, hey, we never got a complete evaluation on this guy, and boy, it sure would be helpful if we had one. And we have a statute in place that discusses that exact procedure that went ignored. And then we had a judge that thought he had no power to do anything other than the
Well,
minimum.
actually, I'm going to push back a little bit on that because you're talking about the court saying he had no discretion. And this is the quote. The judge said at record 15, page 20, the statute specifically says he will not be eligible for parole prior to serving such mandatory minimum term of imprisonment. No other sentence shall be permitted. So the court really does not have a decision today on the length of the sentence in this case. The minimum sentence pursuant to the statute is 554 months. It's a life sentence. That refers to the sentence itself. It doesn't refer to the judge saying, I have no discretion to get an evaluation from Larned. It doesn't indicate he doesn't understand that, does it?
No, what I'm submitting to Your Honor is that he clearly wasn't thinking of a method by which he would not be bound by that statute when the statute exists.
Well, the statute exists for something that happens prior to the time the sentence is actually imposed, however, correct? So at the time the sentence is imposed, if there's not an evaluation done at Larned, then there is a sentence from which the court cannot deviate as to the minimums, correct?
That's true.
And when the judge has an evaluation, a competency evaluation that happens post-trial, the defendant still has the burden of proof to prove he is incompetent, correct? Because there's a presumption of competency.
Yes,
And the judge found based on the report that he was competent, correct?
based upon the last sentence of the report, yes.
Well, based on whatever he considered in his own mind after reading the report, and the report was admitted, the entire report was admitted as evidence, correct?
Yes,
And then the statute says that if this competency evaluation is done after the trial, you can look at what happened during the course of the trial, and if incompetency is found, then there's a mistrial declared, correct?
yes, sir.
But the defendant still has the burden to prove that during the trial, the defendant was incompetent, correct?
Yes,
And the only evidence presented was this report,
well,
correct?
respectfully, no. The only evidence presented is actually the lawyer's statements in the motion for the examination about how during the course of trial, he was asking questions indicating to him that he was not competent during the course of the trial. That combined with this report, which doesn't just say, you know, it does appear he's competent to stand trial, but it goes through his complete history of mental illness.
You're not saying that arguments of counsel are evidence, though, are you?
I'm not saying that it's evidence, but I'm saying it's a determination as to why you would read the entire report that's done and make a determination based upon the entirety of the report, which clearly says if he gets coaching and support, he has the ability to be competent. Now, that's not a, he's good to go. That's a, if he gets this done, then we have competence. We gave it to him here. Now he's good to go.
And the
It
judge,
doesn't, it's not a blanket, hey, he's just good to go for the rest of his life. Because as we can see in the history of this case, we have competency when he's on his meds, incompetency when he's off. Incompetency, he's wearing a pickle suit for crying out loud during the evaluation. You know, he's hearing voices, and then he wants a certain kind of abilify to help him. So does Kansas recognize a conditional competence is another question. And we know we've cited a case outside this jurisdiction in Vermont that recognizes that there can be conditional competence. And then what do we do with it when we're faced with conditional competence? Should there at least be some kind of evidence somewhere that says we made a determination to fulfill those conditions, and here there's none?
and your burden was the preponderance of evidence, correct?
Yes, which we would rely on the report by Crosswinds, a full reading of that report to get you there. And I blew, I think, all my time. My apologies. Thank you. I reserve my arguments on my brief with regard to the other issues. Thank you.
Good morning, Your Honors. If mental health issues in the state of Kansas equaled incompetence, there would be a significant amount of people in the state of Kansas that are incompetent that have been found to be competent, as that is a huge issue. State of Kansas. This case is a case where the defendant had clear mental health problems. The state conceded that at sentencing because it was obvious and his record showed that he had mental health problems. However, Crosswinds found him to be competent. And that competency evaluation should be strongly considered. In reading the entire competency evaluation, it says that the defendant basically acts like a child, wants to control the consequences he has, and that he's manipulative in the system. He wanted to take Abilify for hallucinations, but Abilify was not a prescribed med for hallucinations. He wanted to take the Abilify, but he didn't want it in the dissolvable form. He wanted it in the form he wanted it.
Can I just ask you on the report, the bottom line of it all, I mean, at least arguably is a conditional conclusion of competency if there's certain coaching and support provided for trial. So when you look at that, the conditions placed on the competency conclusion, coupled with the absence of evidence of that coaching and support, why would that not be prima facie evidence, at least, of incompetency? That's the argument that I understand your opposing counsel would be making.
Yes, and in Kansas, conditional competency is not recognized. And while it did say that he needed coaching and support, there were examples of coaching and support that he received from Crosswinds during his evaluation. He was basically given instructions. This is how you should act while you're in custody. You should act right. You shouldn't try and bend the rules. You shouldn't try and go against the rules. And he followed that. So that to the state would not be anything beyond what a defense attorney would be giving the defendant in his own advice and when he's discussing the case with the defendant. In this case, the defense attorney didn't file that motion for competency until after the defendant made a couple comments during trial. He wasn't acting nutty during trial. He made a couple comments to defense counsel that made defense counsel question that competency. However, defense counsel's statements are not evidence, and it's the competency evaluation and also the way the defendant acted during trial. Those are things that the court could take in consideration and could have taken into consideration and presumably would have taken into consideration in determining the competence. If he was acting a certain way during trial, if he was having outbursts, if he was having any issues, if he was actually acting nutty during trial. The court could have considered that. However, there were none of those issues during the trial, and the record doesn't reflect there were any of those issues.
Let's do a hypothetical that, I always use myself. I'm on trial and I'm schizophrenic. And, you know, I mean, it seems to be undisputed that he hears voices. And you know, without divulging anything with attorney-client privilege, I'm hearing voices and I can't help. You know, the attorney says, well, what do you think of this witness, what they said? You know, and he's distracted because he's hearing voices. And that's not something that would show up in a transcript, right?
That is correct. It would not show up in the transcript. But the defense attorney, I think one of the key points is he didn't file this until after trial.
Well, that's what I'm saying. Well, so you're saying he should have filed it as soon as that you know what I see? I'm going to interrupt trial. I see that so you're hanging your hat on the fact of the timing of the request?
I think the timing is a very important factor to consider because the defense attorney did not stop trial. He did not.
Why isn't it better to wait until the end of trial?
Because if he had questions of competency, why would he want to continue the trial and continue going through the trial with an incompetent defendant, as a defendant needs to be competent in order to.
That reality though, saying, okay, you know, maybe he's competent. I'm going to wait and see how things turn. How long was the trial?
Trial was 2 days.
You know, so, you know, well, let me see how he does tomorrow. Maybe he's just having a bad day today, but he really understands and he can help me tomorrow, you know, on cross-examining or giving his opinion about what his defense should be or whatever. I mean, you know, the reality is that everybody agrees he's schizophrenic and has other kind of debilitating mental health conditions. And counsel saw that during trial and filed the motion, and it comes back and says, you know what, he does have all these issues, but he could be competent if he has the support, I forgot the two words, if given coaching and support.
And the evaluation doesn't describe what coaching and support is, but it does give the examples of what Crosswinds did in coaching, and they actually did use the
But
word.
what Crosswinds did, and this is, you know, based on my personal experience of understanding a mental illness, Crosswinds told him, this is how you should act. Okay, so no matter what's going on in your head, you're hearing voices, this is how you should act so that you don't get put in solitary, or so that you don't get injected with Thorazine, or so that you don't do this. So that coaching was how to act when you go back to custody, not can you understand and help, you know, what's going on, and can you help your attorney? I mean, I think I see those two things as totally different.
There's nothing in the record that indicates that he did not receive coaching and support during trial. Defense attorneys are presumably going to have to give some sort of.
Presumably. So
And there's nothing in the record that shows that Mr. Meyer did not give any coaching and support during trial. The record is devoid of that. And it was on the defendant to make that, it was the defendant's burden to show that he was incompetent. But even during trial, when the state rested, defense counsel still stated after he'd had consultation with the defendant had chosen not to testify and they decided not to present any evidence. And so he would have had some sort of consultation and had to discuss the matter with the defendant and had that contact with the defendant in order to make that determination. And the defendant's waiver of his right to testify, he would have had to have been something the defense counsel would have been confident that he was willingly waiving this. And then there were no other signs of incompetence during trial. There
Right,
were
but again, those are outward displays. When schizophrenia is not, I mean, there's, conduct versus, what's going on in his head. It doesn't mean that just because there was no outward displays, lots of times courts find defendants incompetent to help, with their defense and participate in trial, when there's no outward display of aggression or, right?
Yes.
Can you remind, go ahead if you're,
Go ahead, Your Honor.
can you remind me what the time lapse was between the trial and this evaluation?
I believe it was a month or so. I believe defense counsel filed the motion a day or two after trial. However, Crosswinds was backed up, and so they were not able to get that evaluation until after. It was probably a month or so after, I believe, that he was able to get that competency evaluation done. And then we had the competency hearing in April, I believe it was. The competency evaluation, and then we had the sentencing about a month later. So it did take a period of time in order for the defendant to get his evaluation, just because of how Crosswinds had to work it, and they weren't able to get that evaluation done in a timely manner.
Is there any evidence in the
Those-
record to show whether or not he was medicated during trial or medicated when he had the competency evaluation?
I don't believe. I do know that during, it was after trial, he'd indicated that he was not getting some of his meds.
That's in the record.
That I believe he did say that he wasn't getting one of his medications because of, some issue at the jail. The jail wasn't supplying that, whether it be for a financial reason or a prescription reason. But that was a medication that he, in his opinion, believed he needed. And the competency evaluation reflects that the defendant wanted to control stuff.
But it's just a simple question because I know the chief has a question
Well,
too.
well, my question was almost exactly that I hadn't seen anything that gave us information about whether medications might have changed from the time of trial to the time of the evaluation, or that there had been any therapeutic interventions during that time or anything of that nature. So I assume we have nothing in the record about that, or we would know that.
Yes, I do not recall seeing anything in the record that would indicate that anything had changed between the time of trial and the time of the competency evaluation.
Is there any evidence presented during the course of the trial to rebut the presumption of competency?
Can I circle back to something you said earlier, but I think it relates to some of the questions you just answered. When you said Kansas doesn't recognize conditional competency, what does that mean?
So in Kansas, the way the statute is, either you're competent or you're incompetent to stand trial.
I think that is for all time.
I believe at least at this point, there is no case law that indicates that the conditional competency
So let
is.
me draw your attention to 22-3303, which is the long procedures that are set forth for when an individual is found to be incompetent. And that statute uses the phrase attaining competency, like I can't count how many times it's throughout the statute.
Yes.
Is that a synonym for conditional competency?
I don't believe it is, because I think that that's after a finding of incompetency.
Yeah, but
has
how do
been
you,
made.
what does it mean to attain competency? What does it mean to move from a state of incompetency to a state of competency if it's not conditional, if it's not based on the conditions?
Yes, there are some conditions that would have to be met.
Yeah, like
such as-
medication.
Yes, such as
or-
medication or therapy or something like that, which is presumably what they would do.
And isn't that exactly what is meant by the term conditional competency? In other words, just put it in simple English, this person can be competent if they're on the right medication.
It could be interpreted that way. Yes, Your Honor.
Isn't that a cycle we frequently see, that someone will come back from learned or and be competent for a period of time, but then at some point, everybody says, oh, we may need another competency evaluation because there's a difference in behavior or whatever, somebody may come and go for that competency process a number of times before the case.
Yes, throughout my experience, I have seen that multiple times where individuals do come back and become incompetent for various reasons.
And so is that the equivalent of conditional competency?
Like I told Justice Siegel, I believe it could be interpreted that way, that is conditional competency, because obviously a certain condition has to be met in order for that individual to attain competency. And that there are certain conditions that have to be met in order for any individual to attain competency.
Is there any evidence presented that he did coaching?
Your Honor.
Or any evidence presented that he did not receive support?
Could support mean, if given coaching and support, could support be construed to include being on the meds that he was supposed to be on? Because it's very troubling that, and I know this happens a lot. It's a huge concern is that when you are in custody, you don't get your meds. And and I guess the record is clear here that he wasn't.
I think support in one way could be for the meds, but Crosswinds also did speak a lot about the medications that he had been on and his choices that he had made to intentionally go off of those medications at various times throughout his entire time that he'd been treated from the time he was a juvenile.
Right, but I'm not talking, but the time, the question is, well, that poses a question. If you're in custody and your mental health, it's kind of a cycle, you're on your meds and you think, I'm fine, I'm gonna go off my meds. And then when you go off your meds, you're like, you don't even know enough to know that you should be on your meds. But let's say I decide when I'm in custody, I don't want to take my meds. And that makes me incompetent. Should that factor in whether I want to take my meds or not?
I think it should factor in because that's,
Really?
I think it should be.
And what in
a
the statute
factor.
supports that?
I don't believe there's anything in the statute itself that would support that necessarily. But that is something that could be factored in his decision making. And
But if he's incompetent, then he's incompetent to make decisions, right?
correct, Your Honor. But there's nothing in this record that indicates other than
Other than the fact that he wasn't taking wherever he was in custody, wasn't giving him his meds because of price or whatever.
and that was one of the, that was only one thing that the defendant had brought up in court to,
Right, so we don't even know how many
Judge.
other things.
so I don't know any of the other things, and we don't even know what medication it was, if that medication was a medication that was required for competency.
Should we remand for an evidentiary hearing on that issue?
I don't believe so, Judge, because I think the record is clear. And there was sufficient evidence to support the court's finding that he was competent. Crosswinds in their report did not say that he needed to have any of these medications. They did give a list and a history of medications that he had been on and what he had refused to take. But when they did make their finding, they did not say he needs to have these medications in order to continue to maintain competency. They did say he needed coaching and support, which I would argue could be similar to what the defense attorney would be giving is in coaching and support during the trial and during the entire process. But they didn't specifically say he needs to have medication, he needs to have this medication in order to remain competent and in order to attain competency.
Was there an opportunity for an evidentiary hearing where defense counsel could have called whoever did the evaluation and, explored the type of coaching support, what that meant, whether that was there?
We did have a specific competency hearing that defense counsel could have presented evidence at. He chose not to at that time. He chose to just both the
Make
state
argument.
and defense decided to just admit the Crosswinds report into the record.
Wrapping up.
Just that kind of how I started out, that if mental health problems in the state of Kansas equaled incompetence, there'd be a lot more incompetent people in the state of Kansas, which I believe is why we have the statutes we have and why we have evaluations and why courts can consider things beyond just the evaluation. They can consider their observations and their interactions with the defendant. And in this case, there have been numerous interactions that the court had with the defendant, with discussions with waiving his right to a jury trial. There were 2 of those, and the defendant and the court had numerous interactions. The court didn't have any concerns at that time that he brought up, and the defense attorney didn't have any concerns at that time throughout any of that either. Thank you, Your Honors.
I understand there's a concern about what the defense did and didn't do, what evidence did the defense present and what evidence did the defense not present. And what I heard my learned friend say was, we agreed at this hearing that we would both offer this report as the evidence. Almost a stipulation into what we're dealing with. And that report is disturbing. There's no way around it. When you read that report, we're dealing with an individual committed against his will on 3 separate occasions, who everybody agrees is schizophrenic, who 5 different times lacks the ability to understand. And then winds up with an overall, he possesses the ability to understand the legal process when he's showing up in a pickle suit for his own protection. He understands the ability, and he has the ability to understand the legal process if given the coaching and support, but there's no evidence of what that is. There was never any hearing on what that is. Did he ever get that? So the prima facie evidence presented by the defendants is the report itself, because it is a array of how mentally ill this young man is, with an ending that under these conditions, though, we're okay. Then with a finding that, well, we're okay, even though every one of us knows in dealing with this, that these things ebb and flow. If you're doing it with your meds and you're getting the coaching and you're getting the support, but nobody knows. So here we either go with, you know what, nobody knows, and it's tough for you, sorry, but your defense lawyer at the time didn't do what he should have done because nobody really knows and you lose. Or we can read this report, recognize that it was the defense lawyer that brought up the issue, not the issue after the fact, but during the trial, I had these issues. And then here, read these reports where 4 different occasions throughout this report, they're talking about the things he does not understand, the things he does not get, how he suffers from audible hallucinations right then. But you know what? We're not even going to do the evaluation that the statute put in place as a due process replacement for the insanity defense. I mean, that's how it got upheld by our United States Supreme Court, is we're going to, you know what, Kansas, you're okay taking away with the insanity defense.
You know,
because
I just want to interrupt here. You know, I feel like that there is like some conflating going on between the insanity defense and competency to stand trial, because those are 2 totally
Guilty.
separate. Okay.
Yes, Judge.
I just wanted to.
Guilty.
And at the competency hearing, the judge specifically asked, does counsel have any other evidence they wanted to present today? Correct?
Don't need it. We have this, Your Honor. That would be my response. if I
My
were asked that
question though is, isn't it correct that the judge asked specifically, does counsel have any other evidence they wanted to present today?
Yes, and he chose not to present any other evidence. That's a 1507 down the line, but he didn't apparently believe he needed anything beyond what we can read here in black and white to get you there. And what
But,
we read
but
here.
in the black and white, there's nowhere in that report where the expert says, in my opinion, this person was not competent during the trial.
No, it's void as to whether or not. And that might be something we all might want to know too, because if we get a remanded hearing,
Isn't that the problem?
it's
That-
the
that when,
problem.
when your client bore the burden. No, and it's just not there.
Wouldn't that be impossible to prove, though, a month after trial? For an expert to conclude who did not read the trial court transcripts, didn't, that he was incompetent to stand trial? How could you make a conclusion?
Yes, and can't. I
So how
suppose
is this
even-
not just a failure of proof? I mean, I guess we're asking the same question multiple different ways, but.
Well, because what we have is a request within this report for a comprehensive psychological evaluation that would present a much clearer picture. Because
What's the district court supposed to do? Let's put it
Easy.
this way, the district court is having a hearing. That the purpose of the hearing is to receive evidence. To make a fact determination on this most crucial question that's been raised by the defense through a motion. So what is the district court supposed to do when it says, I want to receive all the evidence? You have every opportunity, and counsel says, that's it, that's the evidence.
Yeah, I think to answer Justice Stiegel, you would say this. Well, Judge, KSA 223429 gives you the answer because it gives you the ability to go order a
That's a
complete cycle.
sentencing. That's the conflation we're talking about, isn't it? That statute has nothing to do with competency, does it?
It would allow the judge the ability to have a complete picture of his, according to this evaluation, a much clearer picture of the struggles that he has. Because these people had 2.5 hours over the course of 2 days. You recall he was unexplainably shutting down at one point while he was dressed up in his pickle suit. So the answer would be, well, there's a statute that's right on point that can give me a much clearer picture. I'll send this kid to Larned for a month or whatever, and they can get me a much bigger psychological report so that I can have a full understanding about what Crosswinds is telling me. So that would be our position. Thank you, Your Honors.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this matter under advisement.